Criminal appeal. Then,
FT.
FT, they're not before this bench.
I thought I have got a notification.
Okay, boli. So what is the urgency?
But it is in motion, my lord.
Motion, what is the urgency?
In the filing.
It will come automatically. Why do you mention a motion? Unless it is urgent that you want today or tomorrow.
The date of in the trial tribunal fixed for maybe
When did you file?
file.
It's not an urgent matter. It's come on its own.
It's 2 months. It was filed.
When did you file? Date of filing?
Date of filing will be 17th March.
17 March, not 2 months. Okay, 17 March. Is there any defect? No defect. Have you checked up? Okay, I'll have it on Wednesday.
May it please your lordship. I beg to mention item number 7.
7 years.
Senior counsel A.M. Bora has some personal difficulty. Kindly adjourn for the day.
7 is for orders. Why are you adjourning the matter?
There's an IA, lordship.
You are pressing the IA?
Yes, sir.
Okay. Yes, PP. Yes. On a request made on behalf of 3 AM Bora Learned Senior Counsel for the appellant, matter is adjourned by 2 weeks. Miss B. Bhuya Learned APP is present. Yes.
Much obliged.
I would like to mention a criminal appeal. It was listed for several times, but it is
What is the stage?
it is listed for hearing.
Hearing. Matter which year?
2024 lordship. Considering the age of the petitioner and medical report received from the jail lordship.
24 matter paper book prepared.
Yes, sir.
Okay, if it is for hearing, you can have it for hearing. You can have it for orders, we'll fix for hearing. Next Friday.
My pleasure. My lord, item number 12, my lord. I am yet to receive the copy of the paper book, my lord. So, my lord, matter will come up after 2 weeks, my lord.
Madam, you have received paper book. Okay. 3 NJ Das Learned Amicus appearing for the appellant has submitted that copy of the paper book has not been furnished to him. Registry to serve a copy of the paper book to the learned amicus and the matter be listed for hearing after a week.
Deeply.
May it please your lordship. Your
Yes.
lordship, this is for urgent listing, your lordship. The last matter came on 31st of 1, 2025, and the order was reflecting as it should come as hearing of the last week of February, and since this is April 24th.
Paper book prepared.
Yes, your lordship, paper book is prepared, your lordship.
Have it for orders on Friday. We'll see the matter for orders on Friday.
Oblige, your lord.
Item 15, please. Yes.
Impelled by the obsessive love affairs with the daughter of the respondent number 5, a petitioner has performed his marriage lordship on 10/12/2024. And after that, they were staying at Guwahati lordship.
When was the marriage?
Lordship.
When was the marriage?
Marriage 10/12/2024 lordship. And subsequently, that fact was not disclosed to the parents of the
Basic commando. 10, 12, 24. Marriage by what method?
Islamic rituals lordship.
No, rituals. Not before a kaji.
Not before Kati, that was abolished lordship. Done away with Kati.
Then how was the marriage performed?
The marriage was performed in presence of a Molana lordship, and along with other witnesses, as required by the Mohammedan law. And subsequently, they were staying at Guwahati. And that
You were domicile of which place?
originally from Kamrup is close to Halda.
Where? Kamrup, where?
Kamrup Halda under Bahetasari police station.
Okay. And your wife?
Adjacent village lordship, though village is Dorong joint depot lordship.
Okay. Thereafter, you are staying in Guwahati?
Guwahati lordship.
Yes.
And subsequently lordship, that marriage, regarding the facts of the marriage, was not disclosed by the wife to her parents lordship. And accordingly, her parents arranged her marriage with another person lordship.
Yes.
That was scheduled to be held on lordship 18/4.
Yes.
18/4/2025. And while she did not accede to the directive of her parents, they threatened her with dire consequences. And accordingly, finding no other way, she approached the Olaman police station lordship by way of filing an FIR seeking police protection lordship. That was filed on 8/4. 8/4/2025.
FIR by your wife
Wife, Lordship,
against her parents.
the parents, Lordship. So, Lordship, without taking lawful action pertaining to that affair, Lordship, the official of the All-Over Police Station has detained her, Lordship, from 3 p.m. to 10 p.m., Lordship, and accordingly summoned her parents, Lordship, to the police station.
Hmm. Okay.
And after arrival of the parents in the police station, they have beaten up her, Lordship, inside the police station, Lordship,
Beaten your wife.
wife. And accordingly, it was informed by the petitioner that around 10 p.m. she was released and handed over to her parents
Okay.
against her will, Lordship. So, Lordship, finding no other alternative, I have approached honorable court.
Yes,
filing this
Mr.
petition, Lordship.
Sharma.
This moment notice mein go lordship.
Hey, Harry. মারুটি ভালকে মারি বলে কি নাকি মারি ঘরে
Lordship, in
Oh.
this context,
Yes, what do you say, Mr. Sharma?
Lordship, notice
No, no, we'll issue notice, but what is going on?
that we have the inspection for.
This is in the realm of allegation. We do not know what are the actual facts.
Sure.
But allegations does not appear to be very,
Otherwise, this is the version of the petition, lordship, that we have the instruction.
that of course.
Sure.
That is why I said it is still in the realm of allegations.
Sure.
But some version is there.
Sure.
Lordship, may I submit petition?
Who are the respondents?
Paper Batam, one Lordship, the present High Commissioner Secretary, Home Department.
Yeah, no,
DGP is the
who is respondent number 5?
just father of the wife of the petitioner.
Father of the wife of the petitioner. What is the name of your wife?
Millie Boro.
Hmm?
Millie Boro.
Major.
Major Lordship, 24 years old. May I submit one thing? In this context, Lordship, what should be the rule of a constitutional court in a petition under previous purpose is no more essential, Lordship.
We are not into those things. We are issuing notice at this stage. You reserve your energy for when the other side comes. Okay?
My submission, Lordship, may interact with the wife of the petitioner, Lordship.
Now, first let us issue notice, short notice. Which thana was it? Police station? All women.
One bazar.
All women, Lordship.
One bazar. Yes, you get the instructions.
Sure.
Allegations are serious.
Sure.
You get the instructions. Next Monday we'll take up the matter. Okay? In the meantime, you take steps, but we'll have the matter on Monday for instructions. Okay? From the official respondents. Okay. Your GRA motive?
Mutakin, Lord.
Heard Sri GRA Motaki, Learned Counsel, for the petitioner who has approached this court by making with the grievance that his lawfully married wife is in was kept in illegal detention of the All Women Police Station on 8/4/2025, and thereafter and was also physically assaulted, whereafter she has been put in the custody of the respondent number 5, who is her father. It is the case of the petitioner that on 10/12/2024, the marriage of the petitioner with marriage of the parties was conducted as per Islamic rituals. Full stop. Para. Let notice be issued. Returnable by 4 weeks. 3 P.N. Sharma, Learned State Council, accepts notice on behalf of respondent numbers 1, 2, 3, and 4. Let extra copies be served upon him during the course of the day. let steps be taken for service of notice upon the respondent number 5 by Cut post with AD. Steps by tomorrow. As the allegations are serious in nature, let the learned state council obtain instructions from the concerned official respondents, including the respondent number 3, respondent number 4, and such instructions be placed before this court on, we'll have it on next Monday. Today is what? On 28th, next Monday,
Lord.
get enough time.
Lord.
On 28th, 4. But you take steps today itself,
Madam.
okay? You have not given any documents.
There was no appeal come back.
Huh? Where is your FIR?
FIR was,
FIR by lost by your wife?
FIR was in the custody of my wife, Lordship, and accordingly that was retained by the police authority.
You have not obtained for the copy of the FIR.
See,
18/4/84/2025.
we carry the Xerox copy, Lordship, in order to
No, where is that copy?
copy in the custody of the police force.
No, you could have obtained a copy of the FIR.
I did not
If
provide.
FIR was lost, case was registered.
The case was not registered. Lord. That was the about the petition.
See, you have made very serious statements. We are also moved by your application before us. But if factually you are incorrect,
I
we'll
have
also be
categorically
ready
about
for.
Lordship.
Hmm.
I have categorically about Lordship.
We have checked your affidavit also. That is why. Okay. Yes, Monday next.
But here the paper book is also ready otherwise. And this is, IA has come for suspension of sentence.
No, what is the allegation?
302, my lord.
Huh?
302 stroke 34.
Have it for hearing. Have it for hearing.
On a fixed date, my lord, because since long he has been in custody.
When was he? Since when is in the jail?
My lord, 99 he was arrested.
1999.
Yes.
Thereafter,
Thereafter, my lord,
why so long for filing the appeal? When was the judgment?
no, judgment was on 18/1/2023. The judgment was rendered,
And all
and now we have filed this.
no, during the trial he was in custody.
My lord, I'm not sure, but the
Cannot be.
instruction which I'm because it also to me also it sounds little, my lord. But anyways, my lord,
Oh, no, we'll have it for.
we'll have it.
Okay. For hearing. Heard. 3M Biswas Learned Council for the appellants. So 3 appellants.
Yes, my lord.
Also heard. Miss A. Begum, Learned APP. Assam. Para. The Learned Council for the parties have jointly agreed that since the paper book has been prepared, the appeal itself can be listed for hearing. Para. Accordingly, we direct the appeal to be listed for hearing. Is there any private respondent? There is.
Yes.
Served or not?
Yes, my lord, there is a private respondent upon the pull-up.
Served or not?
Notice, we have taken steps, my lord, long back, my lord, noticed.
You have not taken steps. Your volition, you had made 302 a private respondent, which perhaps may not be necessary. But and you have not even taken steps. You have not even taken steps.
Can it be dispensed?
On 13/3, while the appeal was admitted, in fact, he was not even directed to take steps on but 302, private respondent is not mandatory. It's also and 376D, some provisions of rape.
under
Okay,
COSCO.
if there is necessary, then we'll appoint an amicus. Now, let it be a case for hearing, okay? For কি করলো last time? To be listed for hearing in the third week of June 2025.
Have it up.
I think you.
Basically, the lordship had directed the appellant deposit the ADR maintenance demand draft within 2 weeks. It was deposited after the lapse of 3 weeks, and it was just immediately before the due vacation.
Okay,
So we could not.
directed to deposit the amount of permanent alimony,
Not permanent alimony, lordship, ADR maintenance.
area maintenance, which order? Area maintenance within 2 weeks, comma,
By the order dated 13 March.
2 weeks, comma, the same was done beyond the said period. And in the meantime, the Bihu vacation had intervened, full stop. The learned counsel accordingly prays for some time to take necessary instructions in that matter, including release of the said amount,
Only for
or release of the said amount. Para? List after 2 weeks? List
The
after
date may be fixed, Lordship. It's a simple matter, maybe, Lordship. Maybe dispose of in one date only.
list on. We'll have it on 5th of May.
Lord.
Okay,
Okay.
5th of May, lordship, I have some difficulty. It could be on
7th of May.
lordship, that is a it could be on 2nd of
Can be,
Lordship, the only issue here is the assets and liability affidavit was not filed before the learned trial. That is the only.
Yes, we had, in fact, we have heard this matter for
very
some.
clear, Lord.
Will we, if that can be filed in the appellate stage, why do you remand the matter only for that purpose?
Lordship, the divorce and
Oh, we can do it on 2nd of May.
Keep the object.
My lord, is a matter, my lord.
Yes,
The matter has been referred to the Lawsima, and Lawsima has given the report that the respondent did not appear despite of having received summons. So let the matter be.
I have appeared.
Respondent number 1, the wives.
Already appeared.
Oh, yes, no problem.
Have you filed your wakalat nama?
Yes, Lord. On 10th, we have filed our.
Okay. Records have come. How many witnesses are there
3 witnesses.
from your side, appellant side, and Mr. Decker?
I have no instruction as it, nothing is not.
We'll have it after a week.
Proceed
You take
expertise, my lord.
instruction, we take
It
instruction.
is a expertise judgment, my lord.
Expert is judgment.
Yes,
We have filed it.
despite of having written statement, they did not proceed with the case.
Okay, we'll have it after a week.
Lord.
We take instructions.
Lord.
We have to after 2 weeks, okay.
Lord.
Your name?
Dr. T. Kolita.
Heard Dr. T. Kolita, learned counsel for the appellant, as well as Sri D. Decker, learned counsel for the respondent number 1. Are there more than one respondent?
Yes, Lord. Respondent number 2.
Who's 2?
He is the alleged earlier husband of the respondent number 1.
Served or not?
That-
Dr. Kolita, respondent number 2 served or not?
Sir, my lord. So, but a question of report of the Lawsima court is concerned, sir.
Rajima court report.
2-4 is the order of the law.
My lord, we have taken so many steps. Despite of having received it.
Just a minute, just a minute. কি লিখিলো? And D. Decker for the respondent number 1. So far as the respondent number 2 is concerned, perused the order dated 2/4/2025 passed by the learned Lozima Court, as per which the service upon the said respondent number 2 has been held to be complete. Full stop. The said report is accepted. Para. List. We fix a date.
Yes, sir.
Okay.
19th June, my lord.
Para. 3 Deca. The learned counsel for the respondent number 1 submits and prays for some time to obtain instructions, as he has just entered appearance. Full stop. Para. In view of the aforesaid submission, list this case on
19th June, my lord.
not we'll have a short date.
At the port.
Have his instruction, then we'll fix a date
Okay, my lord.
on 30th of April, 30. Okay.
Right.
Your name is reflected, Mr. Deca?
Yes. Item 4.
Item 4. Yes, madam. Your
Busy listening to others.
your client is Buddhiman. You are not Buddhiman.
No, yes.
We are wondering why.
This is what happens, Lottie, when we do bus dropping. That's what happened with me. I was
No,
listening
what
to
is the
them.
name of your client?
Buddhiram.
Buddhiman.
Buddhiman. I do not know why he did something unbuddhiman.
We are not on the second aspect. We are on the aspect of Buddhiman.
Buddhiman. But I think he did something unbuddhiman. Lordship, as per office note, Lordship 4325 LCR is received. So I think paper book is to be.
Under 302,
Yes, Lordship.
you are an amicus.
Yes, Lordship.
Okay. Anisha, na? Third, Miss R.D. Mazumdar, learned amicus curiae, as well as 3 K.K. Das, learned additional PP Assam, para. Pursuant to the order dated 27/1/2025, the records have been received. Para. Office to prepare the paper book and thereafter place this case for orders so as to fix a date of hearing.
Highly obliged, Lord.
Item 8.
Item 8, yes,
Kindly peruse office note dated Lordship 26/3. Service upon respondent number 2 has not yet served.
yes, madam, OC,
Bihar.
which PS?
OC Bihar actually.
Bihar.
PS Ekma. District Sapra.
OC of which thana?
Bihar. You want to
No, you can take instructions, nothing beyond your jurisdiction.
know out of the state.
You can engage your, the office of the DG and get the instructions. It has to be served somehow. Conviction under
304B Lordship.
304B. Who is the respondent number 2?
It's the informant.
304B, madam, informant required or not? Under Nayak?
Under.
You have the notification of
Yes.
Nayak.
May not be.
No, there is no necessity to route the notice through your office, isn't it? So you have taken steps by what method?
So consult PS.
No, by registered post AD or what?
Photo.
Yes, is conducting the
To the
case.
register.
I am appearing on the.
You have filed objection. Yes,
Official-
yes, yes.
official-
Yes, you want to press the IA. If you want to press the IA, we can. Objections have been filed. Records have come.
Lordship, matter may fix for hearing, Lordship.
Then we'll direct preparation of the paper book. Okay. What is your name?
AJ goes for AR.
For
AR soon. He is out of.
this is item number what?
5, 6, appeal over.
Heard Sri A.J. Ghosh Learned Counsel appearing on instruction of Sri A.R. Sum for the petition, for the appellants, petitioners, appellants, oblique
Applicant.
applicants. Also heard Ms. B. Bhuya Learned APP Assam, para, APP Assam, who has submitted that objection, এখন, yes, no, has been filed in the IA, para. Both the learned counsel has however submitted that since the records have been received, the appeal itself can be heard. Para. We accordingly direct the office to prepare the paper book and thereafter list this case for orders so as to fix a date of hearing. You have this and notice.
Yes. If there is a delay of 35 days under section,
First time.
Yes.
Appeal against?
conviction under section 6 of the
POCSO, notice the delay condonation. Heard. Miss S. Khatanir,
legal
learned legal aid counsel for the applicant who has filed this application under section 5 of the Limitation Act, praying for condonation of delay of 35 days in preferring the appeal. Full stop. The appeal has been preferred against so and so, so and so, so and so. Para. That notice be issued. Returnable by 4 weeks. Sri K.K. Das, learned APP, accepts notice on behalf of Respondent 1. Let steps be taken for service of notice upon the Respondent 2, which is to be routed through the office of the learned PP Assam. Para. Steps by tomorrow. Returnable 4 weeks, no? 6 weeks. We're making returnable 6 weeks. 6 weeks. On the returnable date, let a report. No, by the returnable date, objections may be filed if so advised, and the learned APP shall provide the information regarding service of notice.
Item 16 and 17, supply list.
Sixteen, 17, your lordship, paper book is ready, my lord, or earlier. occasion, paper book
is
ready.
also pending, Lordship. They are in custody for more than 2 years. So I am praying for taking up that IL.
We'll have the, we'll hear the matter. Why are you?
Only thing is that, Lordship, there is
Here
no
the matter.
material at all. Lordship may kindly say that PW2 was relied on. And PW2, although in the examination in chief said a general statement that this person said killed, 4%, 5% name. And in cross-examination, he said that I have deposed in the examination because I was drunk on other day. And on the day of incident also, I was heavily drunk. I do not know what happened. So can this statement be relied on to convict this person? This is the simple issue. And they are in custody for more than 2 years for this kind of evidence.
On the other occasions,
Apart
their
from that, there
contention
is
was
no-
that there was no PP For that reason only matter was, has been taking so long, your lord.
We'll
That
hear
is-
the matter.
Yes, on merit it may be hard.
We'll hear the,
any
we'll
day.
fix a date.
Fine.
Don't worry. Fix a date.
On Thursday, Lordship.
Not this
So
Thursday.
because all, except this statement, I will not,
Not
say
this
nothing
Thursday.
more.
We'll be reasonable. There are matters of even more important than your matter. All matters are important. We'll fix a date. Okay.
I'm only paying shorted because they are in custody for more than 2 years.
Uh, Mr. Ahmed, you're in which matter?
I am in 16.
Huh?
16, he is on injury.
No,
17. Yes.
Why both the matters are the same?
On the issue of non-appearance
why is
of
the
public
main-
prosecutor,
Because
issue is
issue
same
is same.
as regards PP.
No. Why is it listed twice?
Because it was listed on Lordship 11th also. And in the main list today, there was also it was listed. And when we pointed out to the court, then the matters were listed today. So because of there is a order of 11, so it is listed in supply and deleted in main column.
It's deleted in main column.
Yes, but in main list it was listed as 5 and 6.
Yes. It's still there. Okay, doesn't matter. You are,
I mean, as now was in item number 70.
you are S Nawaz. Heard Sri A. Ahmed as well and Sri S. Nawaz, learned counsel for the appellants. Full stop. Also heard Ms. B. Bhuya, learned APP, Assam. Full stop. Though the learned counsel for the appellants. Oh, no, not you. You are already on.
I'm
He's on
working on
interim.
He is on bail.
Though the learned, though Sri Ahmed, learned counsel has pressed his IA seeking suspension of sentence. We are of the opinion that since the paper book has been prepared, the appeals may be heard. Full stop. Para, since urgency has been expressed, we direct listing of the two appeals for hearing on, we give a date. On 8th of May. Come prepared, 8th of May.
So may I pay for one observation that if hearing does not take place, I may be given liberty to place
Hearing
the
will
IA.
be, don't
That
worry.
because Lordship has observed that Lordship of the view that to take up the hearing in hearing.
We have already
So only
expressed
that
that
observation
urgency,
may be
therefore
given.
we have fixed it. No
Because
need
this
of
is a
further
matter-
observation. No need of further observation. Next.
All right.
Item 10 and 11 for hearing.
My lord, here in this death reference matter, my lord, altogether there are 34 witnesses are there. We have taken the ground of juvenility also here in this case, wherein, my lord, the prosecution tried to prove the case to the entry in the register, school register, wherein it is our specific plea that he has never gone to school. And the manner in which this is required to be proved, it's not been done so. Even one of the PW who has been examined here in this case, my lord, PW 7, he happens to be the teacher in that particular school. The manner in which, if it's taken in totality, the whole evidence, chief and the cross, it, my lord, destroys everything with regard to that particular school certificate.
But it is for hearing.
Hearing. So what I am on, that as because we have taken the plea of juvenility, my lord, if your lordship is satisfied with regard to that, a person who doesn't have a birth certificate, a person who doesn't go to school, now how he is to be proved? Then the principle of law that's been laid down by the Supreme Court time and again is regarding ossification.
No, that is the statutory provision.
Yes. So what I
We'll
am
go by
on,
the statute.
yes,
Or the-
my, yes,
That birth certificate or the school register, or if not, the ossification.
ossification. So he has never gone to school. That is our defense.
Your statement is supported by some evidence that he has not gone to the school.
No, in the substantive evidence in the court itself, it has been stated. My
No, is there any evidence to?
yes,
show?
he has. His father has adduced evidence, my lord, and even his
My father has said that he has not gone to school.
not gone to school, and he is a juvenile. And apart from that, in his 313 statement, also he said, "I have never gone to school." That is the.
How was that that school register. proof?
Yes,
How
that
was it
if your
proved?
lordship looks into the PW7, my lord, the school teacher, my lord.
Teacher had come before the court.
Yes, yes.
Okay, what do you propose to do now?
My proposed to do, my lord, if your lordship is satisfied from the deposition of PW7 that yes, prosecution has failed to prove the date of birth with regard to them, then in that case, an inquiry is to be required to be made by a board of doctors.
We'll have a date, you come prepared on the aspect.
But when date of
No, that is only for the death reference. If he is raising an issue of juvenility, which
Yeah.
can be raised at any stage,
Yeah,
you can advance your arguments.
Sure.
And if we are prima facie satisfied that
Sure.
an inquiry is required
be
to be
done.
made, we'll make an inquiry. We
Sure.
will not express our opinion that
Yeah.
he's a juvenile or not a juvenile. It's a fact-finding thing.
Sure.
Yeah.
It is to be done through an inquiry, giving opportunity to all the stakeholders.
Sure.
yeah,
And based on the report, we may take a call.
that is.
Okay, when?
Apni ko.
And if
That is-
Mr. Kamar wants to advance any argument since his,
Lordship,
but his role is only on the deaths.
Yeah,
Because his rules comes in only because there's a death reference.
yeah.
His assistance is required.
Yeah.
You tell us when. Mr. Bhaiya, you tell us a date,
Yeah.
both of you.
May 7th, my lord.
May 7th, maybe some पंचायत secretary there को
We have
You don't stay in a panchayat area, I think.
yes, Lordship.
No, you don't.
There
stay
may
in
be
a
a
panchayat area.
because many lawyers has to go back to vote, my lord, in
No.
panchayat area.
I have seen
I don't think any of you resides in a panchayat
Yeah.
area.
we don't belong.
13 May, my lord, if it is convenient to satisfy.
13 of May is okay.
Lord,
Why is 12th a holiday?
12th
What is there on 12th?
12 Buddha Purnima.
Okay. Sri A.K. Bhuya, learned counsel for the appellant, has raised the issue of juvenility. Full stop. He has also submitted that there are materials on record to support the said plea, which was not taken into consideration in the proper perspective. He has specifically raised the contention that though the age was determined on the basis of a school register, comma, his client had never been to any school. And this aspect is reflected in the records. Para? Miss A. Begum, learned APP. Assam. However, takes some time to go through the aforesaid aspect. Para? In view of the above, let this case be listed for consideration on 13th of May,
13.
2025. Yes.
Deeply.
His name is there.
It is reflective. It's in it.
Okay, okay. What is your name? P. Sri P. D. Chaudhary, learned counsel, is present on behalf of Sri Jed Kamar, learned senior counsel, amicus curiae. Mr. Chaudhary, ask your senior to be present on the next date. He can also assist the court on this aspect also. Okay.
Item 13.
Lordship, conviction under 302, my son killing the mother, my lord. My lord, page 4 is the FIR.
Just give us 2 minutes. You're an amicus, Mr. Tiwari? Madam Bhuya will be appearing. Hmm. Okay. Okay, doesn't matter. 302. You're a legal aid counsel or an amicus?
Amicus.
Why the respondent to informant is made a respondent to?
May
No,
not be
no,
required.
no, that is why we're, if you're a
He was the informant.
legal aid counsel, then you actually present a memo of appeal where you may.
Yes, sir.
But in a case where an amicus is appointed, it is only on the basis of an application made from the jail.
Yes, my lord.
So how the respondent to has come in, I do not know. That is where we are trying to. Madam has just pointed out. If there is no memo of appeal, how do you make the array of parties?
Yes.
If had it been a POXO matter, then yes, could have understood. Okay, doesn't matter. Nine PWs.
Yes, my lord.
Appellant is Bilaluddin Borbhuya.
Pardon.
Name of the deceased?
Hafsa Khatun Parbunia.
Afsar Khatun. Stepmother. Stepmother.
No, my lord. Mother is real, but the fathers were step. She married, my lord. Twice she married. This is
Mother.
the both the
Stepmother.
yes. No, my lord. The mother of the informant and this is same, but the fathers are different, my lord. Yes, my lord. Stepson of the deceased, my lord, is the informant, but otherwise the sons are born from the mother, but the fathers are different, my lord.
Oh, not stepson. Son.
Not
Son, my
son.
Okay.
Yes. Only father is different.
Fathers different. Are from the same mother. Fathers are different.
Yes, please come.
Yes, page 4, my lord, FIR.
Yes,
Married, my lord.
please.
I have the honor to state
Date.
date. Yes, my lord. Date is, my lord,
37.
37, 2018.
By Hilaluddin. Who is he? PW? 1.
PW1, my lord. Informant is the PW1.
Okay.
I have the honor to state that subsequent to the death of my father, Imran Ali Barbuya, my mother Hafsa Khatun Barbuya, aged about 60 years, got married to my parental uncle Harus Ali Barbuya. The accused is the son of Said Harus Ali, and therefore I am the informant and the accused are brother in relation. We have been residing in the same house but separately. At about 6 p.m. on 29/7/2018, following a disagreement over certain family issue, the accused, with an intention of killing my mother, assaulted my mother on various parts of her person by means of a lathi, caused swollen injuries to her, and thus killed her at the place of occurrence. Having heard the hue and cry, I, along with other members of the family, came to the place of occurrence and kept the accused confined inside his house. On being informed of the incident, the police team from Lala police station came to the place of occurrence and took the dead body of my mother and the accused to the police station. I therefore earnestly pray to your good self to be kind enough to take necessary action in this regard and outright. Now, page 7 is the charge framed, my lord. The charges were framed on 21/2/2019, my lord,
It
under
was
302.
registered on 37.
Yes, my lord.
The incident is of
29/7, my lord.
29/7/18 at 6 p.m.
Yes, my lord.
And the next,
On the subsequent day, my lord, the FIR was lodged, my lord.
what time?
My lord, the time of the FIR was, my lord,
10:30
10:30
a.m. Okay,
10:30 a.m., my lord.
page 1. Okay, 10:30. Yes.
Now, charges framed under 302, my lord, and your lordship would find the charges framed on 21/2/2019, page 7, my lord. The charges were explained, read over and explained to the accused, my lord. He pleaded not guilty, my lord, and he claimed to trial. Page 9, my lord, PW.
Yes.
PW1, the informant, my lord. I am the informant. I know the accused Bilaluddin. My mother and the mother of the accused is same. The accused is son of my stepfather. That is to say, the second husband of my mother. The deceased is my mother. Earlier, I, along with my wife and children, used to reside in the same
What is
homestead.
the age of this, your client?
The age of my client is, my lord,
313 statement?
yes, 28, my lord. 30 years, my lord.
30 years. Okay.
In 2019, my lord. By the time, my lord, he's 37 years of age. 36.
No, 30, he was 29 at the time of
Right.
occurrence.
Yes, my lord.
Because this was recorded in October 2019.
Yes, my lord.
And occurrence is of July 2018.
18, my lord.
Okay. Yes.
Thereafter, one day, out of quarrel,
The accused.
the accused inflicted dowel blows at the back neck and back head of my wife about 5-6 months prior to the present occurrence. Thereafter, I started residing separately with my wife. Though I started residing separately, but regularly I used to visit my mother. About 1 year back in the evening, while I was returning home, I heard hue and cry in the house of my mother. Then I rushed there and saw my mother lying down on the ground with head injury, and the accused Bilaluddin was standing with a stick in his hand. I asked the accused about the incident. In reply, he told me that he assaulted mother. Then, out of fear of being beaten by the accused, I went outside. After some time, police came. I do not know who informed the police. Police declared my mother dead. Police took the dead body of my mother and also arrested the accused. Thereafter, I lodged the written ejar by Exhibit 1. Exhibit 1 is my signature. During investigation, police seized the stick, a heavy piece of split up betel nut tree in my presence, while Exhibit 2 is a list and Exhibit 2.1 is my signature. In the year 2001, the accused assaulted one teacher, namely Jamir Master, and he died out of this said assault. I bore all the expenses of that litigation in the juvenile court at Silchar. Now, my lord, cross. The incident occurred during dusk hour. Though I saw the accused standing with this stick, I did not see actual incident of assault. The accused was raising hue and cry, saying, "My Mari Laisi, I killed my mother." At that time, there was none present. At the relevant time, I used to reside in a separate house with my family, but every day I used to visit my mother. The house in which my mother and the accused were residing was comprised of only one room. My mother was suffering from skin disease as well as heart disease. I maintained the livelihood of my mother because the accused is unemployed. There was dispute and quarrel between, it should have been me, my lord, me and the accused, but not in regard to landed property. It is not a fact that I had land dispute with the accused. Since 3 years before the incident, my mother was residing with the accused. It is not a fact that my mother was suffering from severe skin disease, and out of fear of infection to the person of my family members, my wife did not allow me to live with my mother. It is not a fact that the accused always wants to live with, it should have been me, my lord, me, all including my mother, together my wife, but my wife did not allow to do so. It is not a fact that at the relevant time of incident, the accused was working in a workshop at Lala. About 6-7 years back, the accused used to work in a workshop. The accused made my mother to seek alms, and sometimes from that source of income, my mother also contributed to the livelihood of her and the accused. It is not a fact that when my mother was begging, I wanted to sell the house of my mother, and out of that, there was a quarrel between me and the accused and my mother. I tried to take my mother to my house, but she did not respond to that, as she always likes to stay with the youngest son, which the accused. My mother loved the accused very much. I heard the sound of hue and cry from a distance around 7 to 8 nell from the place of occurrence. At about 10 minutes, people started gathering. It is not a fact that I have stated falsely that the accused was raising hue and cry, "My Mari Laisi, I killed my mother. My mother died on the spot." It is not a fact that I have stated falsely that the accused was standing with a piece of betel nut tree. It is not a fact that my mother died due to illness and out of girth of land dispute. I filed a case implicating the accused person with a view to grab his land. The accused has got another brother. He also asked me to file the case. At the relevant time, said brother of the accused was residing in Bengaluru. It is not a fact that since the case is filed with false allegation, said brother of the accused did not file any case. After the incident, I talked to the state brother of accused over mobile phone. It is not a fact that I showed the piece of betel nut tree to the police and then the police seized it. It is not a fact that the accused never assaulted my wife, but only to harass the accused, I have made the false allegation. My mother died at the age of about 70 years. I have the record of the case against the accused pending in the juvenile court at Silchar, but today I have not brought it. It is not a fact that I have stated falsely that the accused killed the master. He was referring about Damir Master, my lord, against whom the juvenile cases was going on at Silchar, my lord. Now, my lord, PW2, my lord, he's Abdul Sattar, he's the neighbor, my lord. By occupation, he's the cultivist, my lord.
The injury was on the head.
Yes, my lord.
Head.
One injury was there in the head, my lord, on the frontal bone, my lord.
It caused fracture of the left frontal bone,
Yes. And
leading
clot
to
in the chest
clotting of the blood,
on the
as a result of which there was a massive heart attack.
massive heart. Can I read, my lord? PW2.
Yeah, just a minute. Yes, please.
I know the accused person Bilaluddin. I also know the informant Hilaluddin Barbuya, brother of accused. The disease is their mother. About 8-9 months back, one day at about 6 p.m., I heard hue and cry in the house of the accused person. Then I went there and saw many people gathered there. I also saw the accused person standing there with a heavy stick type piece of betel nut tree in his hand, and his mother was lying on the ground of the veranda. The accused was also saying that his mother was expired. In the meantime, police came and took the accused person and the dead body of his mother. Police seized the piece of betel nut tree in my presence. The material exhibit 1 is the state piece of betel nut tree available in the court. In the year 2016, the accused very brutally assaulted his sister-in-law, Raimun Nessa, by means of sharp dowel, and due to timely treatment as SMCH, she got her life, and in that connection, the accused was in jail for 3 months in connection with Hailakandi PS case number 382/2016. Annexure A is the certified copy of the FIR, and Annexure B is the certified copy of the written HR. Under objection by defense of that PS case, police recorded my statement.
Who is this Abdul Sattar?
He is a neighbor, man. Now, what the informant could not exhibit, my lord, he has exhibited through PW2, my lord.
No, that is not a relevant factor.
No, that is not relevant, but otherwise
That
I'm
is
saying though, my
that has
lord,
got nothing to
because what he finished on the last date, he introduced those documents through PW2. My lord, there is a difficulty in this case because in 313, this accused person has confessed that he has killed his mother because she did not give the PPL card to him. So, my lord, at one aspect, your lord would appreciate that even my lord, if since 313 is not on oath, my lord, it's not a substantive piece of evidence, but my lord, the inculpatory statement, my lord, that can be corroborated with the prosecution witness, my lord. In that case, my lord,
no, there is no eyewitness.
there is no eye.
The PW1 had said that he found while he was coming home in the evening,
Yes.
he could hear hue and cry from the house of the mother. He went there, mother was lying on the floor with head injuries, accused was standing beside her with a stick, and he confessed before him. Extrajudicial. Extrajudicial. The nature of the injuries, we have just checked the post-mortem, is more or less corresponding with the nature of the description made by PW1.
Right.
That heavy stick. He has also described the betel nut, uprooted betel nut. And there was fracture on the frontal area of the skull.
But otherwise, my lord, the IO says that none of the witnesses have stated that the accused was standing with the betel nut stick tree.
No, IO came later on.
But otherwise, my lord,
No, you do not expect a person to stand with the betel nut.
That apart, my lord, the other PWs, they don't even say that they have seen the informant standing there while they reach at the place of occurrence.
No, Mr. See, we have to view it in a practical manner.
Practical.
When the hue and cry was made, this informant, PW1, goes inside the room. He finds the accused with a stick. You do not expect the accused to remain in that position till other people come, till the police come. So that fact not being corroborated by others may not be very relevant because from a practical part, it is not even expected that he will remain there with the stick, let the other people who see him. Naturally, he'll leave and try to flee. We do not know what has happened here.
And the past criminal antecedents of this accused, my lord, also gives serious doubt that he has done. It is there, my lord, on record. Because
Give serious
everybody is
doubt, no, not serious doubt, leaves very little doubt.
little doubt.
You are making a wrong statement. Leaves little doubt that he has made.
Yes,
No,
sir.
but those may not be absolutely relevant.
Relevant.
May be relevant, but not absolutely relevant. Cannot be the basis that he was indulging in activities. So
He might have done both.
no. We have to examine this case on the basis
Based
of
of
the
the
evidence
evidence
that
led
is
by the
connected
prosecution,
to this case.
Yes, sir.
Some incident happening while he was a juvenile, yes, maybe a part to show his nature of his conduct, aggressive nature. But yes, what are the other evidence? Abdul Sattar is, where is he said that he's a neighbor?
My lord, the neighbor part has been spelled out in the, my lord, IO's evidence, my lord.
Okay, they are residents of
village, sir.
Bishnupur. He is also from Bishnupur.
Bishnupur.
Okay. Well, this is their mother.
Here is the cross part, my lord, base 13.
Just a minute, I heard hue and cry. He also hears hue and cry.
Yes.
6 p.m. Right. And there are so many people. See, while the PW2 had reached the place of occurrence, there were already many people gathered. Read the fourth line of page 12.
Yes, my lord. Then I went there and saw many people gathered there. And the incident is at the veranda, my lord. Of the house.
Is it? No, this veranda thing, PW1 has not said. Has he said?
Yes, I check it. No one. He has not figured about veranda, my lord.
And in his cross-examination, he says that there is only one room
Yes, only
where
one.
the accused appellant and his mother used to stay. Only one room.
But the other PW
Please
says that there were 3 rooms in the house, my lord.
No, the house of the PW1,
Yes, my lord.
is it in the same compound?
Yes, same compound, my lord.
Where has he said?
My lord, I'll just show, my lord. कितने को होता है?
Page, Madam?
63, my lord.
Room, place of occurrence, that is room of his play, room of accused Bilal. Also accused and deceased. Also Abdul Sattar. House of Hilaluddin has not been stated.
No,
This is why,
because he is studying in a different house with his wife, my lord.
no, if the house of Abdul Sattar could have been indicated,
Yes.
house of Safir Ahmed could have been indicated, that means Hilal does not stay in the same compound.
No, Hilal does not stay in the same compound, but prior to that, he was staying in the same.
The lordship. I
Prior
used
to
to
that.
reside in a separate house with my family, but every day I used to.
No, that we have read.
Yes,
See,
but the
two-
same compound.
Two houses may be in the
Yes.
same campus.
My lord.
So the proximity becomes easier.
Yes.
He can hear.
Hmm.
Now he says that one evening he was returning home while then he heard hue and cry from the house of his mother.
House of-
Whether his house was also in the same campus, we were just trying to ascertain.
Yes,
If you come to page 63, the sketch map,
my lord.
read with 64, you'll find that two other houses have been indicated. House of one Safir Ahmed, house of one Abdul Sattar, D&E.
Yes.
But this house of Hilaluddin is not there.
Not there.
Not there.
So his house is not in the same campus.
Same.
Abdul Sattar is PW two.
Yes.
Is Safar is also witness?
Sattar is witness, my lord.
No, Safar.
Safar is not.
Suffer Ahmed.
Not a witness, my lord.
Yeah.
Safir Ahmed, my witness.
PW two does not say about Jamir Master.
Yes.
Has he said anything? PW two? No.
No, my lord.
He only says about the sister-in-law's incident.
Yes, sir.
Okay. Nearby my house. Accused is my neighbor. At page 13, he says accused is my neighbor.
Accused is my.
Potato control.
Married, my.
What is the measurement of null? Any
Null is,
idea?
my lord. One null equals to, my lord, 10 feet, my lord.
Yes, madam. Google.
10 feet.
Mr. Tiwari is very confident.
Yes.
My lord, I checked out, my lord.
Not found. Mr. Borua perhaps knows. What is the null? Distance. Measurement of distance. It doesn't matter. There are 3 rooms. There are 3 rooms.
Three rooms the house to take.
one of the, bracket null or 12.
12 feet,
Somewhere I have found
12 feet.
one Mojadari tar within bracket null or 12 feet.
So he is more or less correct. 10 feet. Means by only 2 feet. Okay, next. Case of the deceased. From 18, you are in jail, in custody,
Yes.
as an under trial also. That is where we're trying to see the post-mortem. What kind of injuries was it? If there was any scope to convert. Chances appears to be less.
Yes.
Okay, next.
My lord, PW3, my lord,
Hmm.
is Abdul Mali Laskar. He is also from the same village, my lord, Vishnupur. By occupation, he is a businessman, my lord.
Please read.
I know the accused Bilaluddin. I know the informant Hilaluddin. The accused and the informants are brothers. They are my neighbors. Their disease is their mother. About 8-9 months back in the evening at about 6 p.m., while I was in my house, I heard hue and cry in the house of the accused person. Then I came out from the house and heard that accused Bilal killed his mother. Then I went to the house of the accused Bilal and found him standing near his mother with a piece of betel nut tree in his hand. The accused was saying that he had killed his mother. His mother was lying dead in doorstep of the veranda. Thereafter, police came and took the dead body and the accused. Cross. Immediate after the incident, I went to the place of occurrence. My house is situated towards west of the house of the accused at a distance of around 20 to 25 nulls. When I went there, I saw the accused was shouting and saying that he had killed his mother. And out of fear, none of the gathered people went near the dead body and the accused, because the accused was waving the piece of betel nut tree towards the gathered people. It is not a fact that I did not state before the police that the accused was saying that he had killed his mother. The informant is a truck driver by profession. I never hired the vehicle of the informant for my use. I know the informant since he is my neighbor. The informant sometimes reside in his original home and sometimes in his new house. The accused used to enjoy fruit from his homestead productions such as betel nut, coconut, etc. Hilaluddin used to look after his mother. In the year 2016, the accused brutally assaulted the wife of the informant by means of dao. And thereafter, the informant started residing separately, but he was very much dutiful to his mother. The disease did not have any income. The disease was suffering from skin disease, but she was otherwise physically sound and she was capable to move. Police at the place of occurrence after about 1 hour of the occurrence. It is not a fact that I did not state before the police that accused was standing with a piece of betel nut tree in his hand. I do not know why the accused assaulted his sister-in-law. The informant and the accused had good relation. It is not a fact that I have deposed falsely today. It is not a fact that Hilal wants to grab the land of the accused, and with that intent, he has falsely implicated the accused in the case where his mother died a natural death. PW4 is the doctor who conducted the postmortem with 7.
Yes, please.
On 30/7/2018, I was working as SMO at Civil Hospital, Hailakandi, and on that day at 10 to 11 a.m. on police requisition in reference to Lala PS GDE number 16, dated 29/7/2018, I performed the post-mortem examination on the dead body of Hafsa Khatun Barbuya, aged 60 years, wife of late Harun Ali Barbuya of village Bishnupur under Lala PS, Hailakandi, and found the following. The dead body found at the SK Roy Civil Hospital, Hailakandi, and the dead body was accompanied by Abdul Malik Losfer, Hilaluddin Barbuya, and UPC 256 Dilwar Hussain Barbuya at Lala PS. The dead body was identified to me by one Hilaluddin Losfer, Abdul Malik Losfer, UPC 256 Dilwar Hussain Barbuya. An old lady of 60 years, approximately of height 150 cm, triggers motives present in all 4 limbs, physical ill health, injuries, abrasion of size 3 cm into 1 cm on L3 vertebrae waist, direction oblique, abrasion of size 2 cm into 1 cm on C3, C4 vertebrae, neck, abrasion of size 2 cm into 1 cm in upper part of neck, direction oblique, soft tissue swelling on size 3 cm into 1 cm into 1 cm on upper left upper side of the frontal bone, just above the eye. Semi-digested food material present inside the stomach, having no offensive smell on heart. Presence of one large clot in the descending branch of left coronary artery. Left side of the heart is pale white. There are hypertrophic of the left side of the heart. Perineum, soft tissue swelling as described earlier on left side of the frontal bone. Collection of 100 ml of blood in extra dual space in the left frontal region with hairline fracture of left frontal bone. More detailed description of injuries. Massive heart attack due to blockage of coronary artery plus collection of blood in the brain. Cardiogenic shock. In my opinion, the cause of death is due to massive MI along with previous injury on head. Time since death 12 to 24 hours. The disease was perhaps suffering from hypertension and old age ailing problems, including heart disease, and the injuries which had been described above, when inflicted upon, she was badly affected and resulted in death. Exhibit 3 is the now in the cross part, my lord, the suggestion was made, my lord, the hand injuries as described above were not occurred by falling. So, my lord, that makes it clear that only by a stick or harsh substance, my lord, injury was inflicted
Abrasion
on the
may
head.
be by falling.
Yes, abrasion might be by falling, my lord. That is there, my lord.
Yes.
But the injuries were, my lord, with a harsh substance. PW5, my lord. Akram Ali Barbuya is also from the same village, my lord. Cultivator, my lord, again by profession.
Yes.
Informant Hilaluddin Barbuya is my cousin. The accused Bilaluddin is also my cousin. About 1 year back, one day at about 3 p.m. So my lord, the time is only not matching. While I was on the way to my house, near the house of the accused person, I heard hue and cry in the house of the accused, and I rushed to his house and saw mother of the accused lying on the ground of veranda of house, and the accused Bilal was standing there with a lathi in his hand. When I came to the place of occurrence, I heard from the mouth of people that accused has killed his mother. Thereafter, I left the house of the accused. I do not know why the accused killed his mother. Cross. I did not see the accused assaulting his mother, but I saw him standing with a lathi near his mother. I saw the same from the entrance gate of the house of the accused, but I did not enter inside. It is not a fact that I did not state before the police that I saw the mother of the accused lying inside her house, and the accused was inside. Accused Bilal and the informant Hilal are from common mother, but their fathers are different. It is not a fact that the informant has got property dispute with the accused, and as such he has implicated the accused with the false allegation of killing his mother, despite knowing the fact that his mother died a natural death. It is not a fact that I deposed falsely for the sake of informant. PW6, my lord, Kapil Hussain Barbuya, from the same village, my lord, and he's a daily wage earner, my lord.
Yes.
I know the informant Hilaluddin and accused Bilaluddin. They are brothers. About 1 year back, one day at about 4 p.m., I heard hue and cry in the house of the accused, and then I went to his house and found the mother of the accused lying on the ground inside the house, and the accused was being armed with a small lathi made of betel nut tree, and the accused was shouting, saying that his mother died. His mother died. From the condition of the accused, I realized that he himself killed his mother. The accused is a person of very hot temperament, and previously he did such type of incident, and as such, out of fear, I did not proceed further and left the place of occurrence. After some time, police came, and then I again came to the place of occurrence. Police said lathi in my presence, while Exhibit 2 and Exhibit 2.2 is my signature. Cross. It is not a fact that I did not state before police that about 1 year back, one day at about 4 p.m., I heard hue and cry in the house of the accused, and then I went to his house and found the mother of the accused lying on the ground inside the house, and the accused was being armed with a small lathi made of betel nut tree, and the accused was shouting, saying that his mother died. His mother died. From the condition of the accused, I realized that he himself killed his mother. The accused is a person of hot temperament, and previously he did such type of incident, and as such, out of fear, I did not proceed further and left the place of occurrence. And I have stated the same today in the court postly.
This is the contradiction tried to be
Yes,
proved.
tried to. I did not see the actual incident of assault. We showed the lathi to the police. Now, this part, my lord, we showed the lathi to the police and stated that we saw the accused standing with the lathi. From the early hours of the day, we heard outcry of the mother of the accused, and we realized that accused was assaulting his mother. My house is very near to the house of the accused, but out of fear, I did not go there. My house is at a distance of 10 meters from the house of the accused. To the north of the house of the accused, to the house of Gule Ahmad is situated. To the south of the house of accused, the house of Sattar Mia is situated, but my house is even nearer than their house to the house of the accused. House of the accused. It is not a fact that I have to post falsely. My lord, his house was not shown in the sketch map, my lord. Page 63. 64 is the index, madam.
Yes.
Now this Pule Ahmed, my lord, he was not examined. It. PW7, my lord, Samsul Haq Barbhuiyan. He's from the same village. He's a driver of a motor vehicle, my lord. As reflected. Page 22. Ma'am.
Yes.
The accused and the informants are my neighbors. About 1 year back, one day at about 6:30 p.m., I returned home from my work and came to know from people that accused killed his mother. I went there to the house of the accused and saw the dead body covered with clothes inside the house. Cross. I have got no personal knowledge about the occurrence. Police asked me about the incident. I came to know from informant Hilal Sattar and others that the accused killed his mother. It is not a fact that I have stated.
He's a hearsay.
He's a hearsay. PW8. Rafiq Putin Mojumdar is also a cultivator, my lord, by profession.
Rafiq.
Putin Mojumdar.
Yes.
I know the informant Hilaluddin and the accused Bilaluddin, and both are brothers, so same mother, but their fathers are different. They are my neighbors. About 5-6 months back, one day about 6 p.m. on hearing hue and cry, I went to the house of the accused and from a little distance, I saw his mother lying dead on the floor of the veranda of his house, and there was a piece of betel tree in the hands of accused, and the accused was shouting towards me not to come near his mother, otherwise he would kill us. I found the accused dragging his mother from veranda to inside his house. A few years back, the accused killed one domil master of our village. Thereafter, the accused also brutally assaulted his sister-in-law, even inflicted thou blow at her neck, but somehow she survived. Therefore, on seeing the condition, I and other village people did not go forward. Cross. The distance between my house and the house of the accused is around 50 meters. At the relevant time, I was in my house. I did not see the accused assaulting his mother. It is not a fact that I have stated falsely that I saw the mother of the accused was lying dead in the veranda. At the time of murder of Domil Master, the accused was juvenile and it was occurred in the year 2001. I cannot say the number of that murder case. It is not a fact that accused did not commit any such murder. I also do not know if any case was filed by the sister-in-law of the accused against the accused for the alleged assault. It is not a fact that the accused did not kill his mother. Rather, she died due to heart attack. It is not a fact that the informant filed the case against the accused in order to deprive him from his paternal property. It is not a fact that I have deposed falsely. PW9 is the IO. Sri Vijay Roy. On 29/7/2018, I was attached to Lala PS as SI of police. And on that day at 8:30 p.m., the then OC of Lala PS, namely SI Monirul Islam, received a phone call from an unknown number to the effect that the accused Bilaluddin has killed his mother, Hafsa Khatun Barbuya, and accordingly, he made GDE number 16 dated 29/7/2018 and went to the place of occurrence along with me. Exhibit 4 is the copy of the state GD entry. On arrival of the place of occurrence, I found the accused person was there confined by the people in his house. Now, he only says that he was confined by people, but the people are saying that they did not even dare to go in front of him. We also found the dead body of his mother, Hafsa Khatun, lying on the floor of the house with head injury, and there was profuse bleeding, and a stick was also found lying near the dead body. I seized the stick by Exhibit 2, scissor list in presence of witness, and Exhibit 2-3 is my signature. On that night, I examined witness Hilaluddin Barbhuiya, Abdul Malik Loskar, and Abdul Sattar Barbhuiya. I sent the dead body for post-mortem examination. On the next day, that is to say on 30/7/2018, the executive magistrate Srimati Madhumita Nath conducted inquest over the dead body, and thereafter post-mortem was done. Exhibit 5 is the inquest report, and Exhibit 5(1) is the signature of Srimati Madhumita Nath, which I know. On that day, the OC received the FIR from one Hilaluddin Barbhuiya. Exhibit 1, right? Exhibit 1. Exhibit 6 is the FIR form, and Exhibit 6(1) is the signature of Moinul Islam with his endorsement empowering me to investigate the case. I prepared the rough sketch map of the place of occurrence, right? Exhibit 7. Exhibit 7 is my signature. Thereafter, I examined the witnesses Rafiqur Uddin Majumdar, Akram Ali Barbhuiya, and Samsul Haq Lokpur. Thereafter, I collected the post-mortem report and submitted charge sheet against the accused Bilaluddin Barbhuiya, white Exhibit 8. Charge sheet under 302 IPC, and Exhibit 81 is my signature. Cross. We arrived at the place of occurrence at 9 p.m. on the date of occurrence. I found the accused being confined by the public in his house. We did not find any weapon in his hand of the accused. I have not seen the seized stick in the court today. In the sketch map, I did not indicate the place where from the stick was seized. PW2 Abdul Sattar did not state before me that the accused assaulted his sister-in-law with a dao prior to the present incident. The PW2 did not state before me that he saw the accused standing with a stick in his hand near the deceased. PW3 Abdul Malik Loskar did not state before me that accused was standing with a piece of betel tree in his hand. The PW3 also did not state before me that the accused was saying that he has killed his mother. PW6 Kapil Hussain Barbuya did not state before me that about 1 year back, one day at about 4 p.m., he heard hue and cry in the house of the accused, and then he went to the house of the accused and found his mother lying on the ground inside the house, and the accused was being armed with a small lathi made of betel nut tree, and the accused was shouting, saying his mother died. And from the condition of the accused, he realized that the accused himself killed his mother, and the accused is a person of very hot temperament. And previously, he also did such type of incident, and as such, out of fear, he did not proceed further and left the place of occurrence. The actual place where the dead body was lying has been marked as O in the sketch map. The neighboring people, as has been shown in the sketch map, out of them, only one person was examined. The inquest was conducted on 30/7/18 at 9 a.m. at the S.K. Roy Civil Hospital, Hailakot. So these are the evidences which are led by the prosecution in the case. Page 28 is the 313 statement.
How do you reconcile this at page 25?
Yes.
At page 25, towards the last part. On that night, I examined witnesses. Have you got?
Yes, my lord.
I examined witnesses Hilal,
Hilaluddin Barbuya, Abdul
Barbuya,
Malik.
Abdul Sattar Laskar,
Yes.
and Abdul Sattar Barbuya. Then if you turn over 2 pages, come to page 27,
Yes, my lord.
the last sentence, second last sentence.
Yes.
The neighboring people, as has been shown in the sketch, out of them, only one person was examined.
To my understanding, that is Abdul Sattar only, my lord.
No, but he has examined, he said he has given 2 other names.
2 other names, my lord.
Because why we are asking, because there would be a significance as contradiction is tried to be
Yes.
proved. Now, if you do not even examine a person under 161, normally only those persons who are examined are produced as witnesses, depending on what statement they had given before the police. Now, a person who was not even examined by police will hardly be produced as a witness in a criminal case. Now, he says that he had examined Hilal, Abdul Malik Laskar, and Abdul Sattar Barbuya.
Yes, ma'am.
And only those. So for PW6 is concerned, Kabil Hussain Barbuya,
Yes, ma'am.
he has not stated that he examined Kabil Hussain Barbuya under 161. So the question of Kabil Hussain Barbuya saying something before him will not even come. It will not be a contradiction.
That it will be better.
Because in one of our judgments, we have already also dealt with this matter. What is a contradiction? What is an omission? Contradiction is what is starkingly, it is different. One version here, the other version. One is omission, something said here, not said there.
Both.
Omission can be is a curable thing, but contradiction may not be. Now here may be a situation where 161 was not even there.
There.
So putting a question that you have not stated before the police obviously has to be answered, yes, he has not stated before me because I have never examined.
Oh.
You see the case records, CD. Three persons, he said.
No, my lord, but at page 26, my lord, he says that, my 4th line, my lord, thereafter I examined the witness Rafiquddin Majumdar, Akram Ali Barbuya, and Samtullah Laskar. At page 26, my lord,
But what
4th line.
about Kabil Hussain?
No,
Kabil Hussain, he has not said.
he has not said, my lord.
One of the contradiction is with Kabil
Yes.
Hussain.
Yes, my lord. PW. Statement is there.
Kabil Hussain. In vernacular.
উপৰোক্ত মতে আমাৰ নাম আৰু ঠিকনা চোৱা আমাৰ জবানবন্দী এই যে আমাৰ সন্মুখে লালা থানাৰ পুলিচ একটা সুপারি লাঠি জব্দ কৰে আসামি বিলালুদ্দিন তাহাৰ মাকে মাৰিয়া হত্যা কৰিছিল আমি এই জব্দনামাই সহি কৰি জব্দ কৰা সুপাৰি yes.
See, the importance of 161 is significant. Those are not required to be signed. Those are hardly read over, and yet the defense get full opportunity to contradict.
Right.
The duty of the IO is very significant. See, justice has to be done.
Right.
It's not favoring one party and not favoring the other. What is there has to be there. If he has not something you are not required to put it down. But he may not know what is required to be stated. And he doesn't sign. Most of the persons are illiterate. They will not even know what has been recorded. And tomorrow this statement will be put to him. Did you say? I do not know anything what I have stated to the police. And those happens at the heat of the moment. People at that time are mostly our family members, neighbors, they're in a frenzy. What to say, what not to say, they're not. So 161, the importance is grave. But okay, yes. These are the witnesses.
Yes, my lord, these are the witnesses.
Of the neighbor.
He's saying the neighbors as shown in the sketch.
Who are the neighbors?
So in the sketch map, there are Sarif Ahmed Chowdhury and Abdul Sattar. No?
Hmm,
So he has examined only Abdul Sattar.
okay.
That's what he meant that out of the sketch map.
Correct, correct.
Yes.
But so far as PW6 contradiction is there,
Yes.
and but we have seen PW6 was the statement under 161 was recorded.
Mm.
So probably they had only right to put this question.
Okay, yes.
Now, page 28 is the statement at 313, my lord. The first question which was put to the accused, my lord,
Yes, I killed my mother.
yes,
Okay.
he has confessed that he has killed his mother. The version of the informant he has admitted. Second question he also admits. Third also he admits. Fourth also he admits. Now sixth he says that he gives an explanation, my lord, in the question number 6, page 30. The PW has further deposed that in the year 2016, one day you assaulted your sister-in-law, Raymond Nesta, very brutally by means of sharp thou, and due to timely treatment, she got her life. And in that connection, you were in jail for 3 months.
No, that is with regard to the other
The other,
sisters,
yes.
sisters.
Question page 33.
7 he has admitted.
Yes. 7 is also admitted, my lord. 8, my lord, since it was in postmortem report, my lord, so he said he does not know about that.
All admitted.
All admitted. Page 33, last, my lord, the explanation part. Anything to say? More to say? State, I have killed my mother as she refused to hand over the BPL card to. And page 35, my lord. Hearing on the point of sentence, my lord, he says, I told the truth, I may be treated leniently. I would not commit such type of incident. I tried to take out.
Yes, madam, why didn't you obtain a confession statement if that was his conduct? Matter would have been much easier for you. The evidentiary value of 313, you know how much.
Right.
It is not under any oath. That cannot be the sole. But corroborations in these cases that the confession would have been the end of the matter.
Right.
End of.
And with this conduct, perhaps confession would have been not a very difficult job.
Difficult job.
Okay. Yes. What are your submission?
Well, my first submission, my lord, is that, my lord, as far as, my lord, apart from PW1, my lord, none of the other witnesses say that they have seen the informant at the place. Nobody says.
No. They have said. They have said.
No, my lord. Nobody
Yes,
says that.
Yes, yes.
They have seen Hilaluddin. Nobody says so, my lord. From PW2 to, my lord, PW9, nobody says that they have seen Hilaluddin at the place of the informant at the place of offense.
Informant.
Yes.
You're on the informant.
Yes, on the informant. On the point of, my lord, whatever the informant is saying that he heard hue and cry, my lord. But, my lord, second part your lordship would appreciate, by the time the informant also reached, my lord, the mother already died, my lord.
Yes.
Now your lordship would find that one of the neighbors who saw him was residing 50 meters away from the residence, my lord. Now everybody hears the hue and cry, but by the time everybody reached, the mother is died. But nobody says that they have heard that the mother screaming. The mother screaming, that was not there.
No, none has
Even
said-
otherwise, it can be
none-
presumed that
none
it
of
was
them-
the accused who himself was saying, my mother has died, my mother has died.
No, that is
That might-
different. So far as the hue and cry is concerned, none of the witnesses have stated anything specific about the hue and cry. They have just stated, deposed that there was hue and cry. Who was making the hue and cry?
That
That has
nobody
not
has
come.
said.
That has not come. No, what are you trying to say? That regarding the informant?
Informant, my lord, even if he says so, my lord, that he went there, he saw his brother standing with that,
Mm.
but that part was not corroborated by the other, only as far as the presence of the first presence of the informant at the place of occurrence. Because he says in its evidence that while he reached at the place of occurrence, none was present there, my lord. That I'll just show.
Now, how will it make any impact on your
No,
case?
I'm not on that, but my lord, how it would. But
See, the other witnesses may not have specifically named the informant that he was already present, but they have said that while we had reached, there were other people also. But if not mentioning the presence of the informant, how is it going to materially affect the outcome of the case?
how come, my lord, I'm not there on that? One points I'm just placing, my lord. Second was that, my lord, everybody says that if they have seen the accused standing with the witness, or some have said that he was waving over them also.
Okay.
But while the IO makes a statement in the court, my lord, he says that by the time he reached at the place of occurrence, he saw people have confined the accused.
Hmm.
Once everybody in the witness box who turned out in the court said that we were frightened to go near the person, then how come the person can be confined then, my lord? Second
When did
question,
the IO reach?
IO reached at about
9. So 3 hours, he'll not keep on waving.
Yes, my lord.
And
That's
people
there,
will
my
not,
lord.
people may not go near him, but people will not leave their place. Confining
Otherwise,
doesn't
my lord,
mean that he
otherwise, so, my lord, the prosecution evidence is consistent with the, my lord, materials because he was seen with this witness stick, my lord. That apart, my lord, inference under 106, my lord, only he was residing with
No,
the
you
mother,
see
my lord.
why this question has been put to you by us. You come to page 5, the part of the FIR, which
Yes, sir.
we just remember. Page 5, second line. Having heard
And
the
hue and
hue and
cry,
cry
along with the other
family
members of
members,
the family,
came to the place of occurrence, kept the accused confined
confined
in this
inside
place,
his house.
and on being informed by the police team from so and so and took the dead and the accused to the police station. The confining aspect was also mentioned because the FIR was lodged on the next morning.
Next one. Next.
You could have argued on the aspect of the nature of injuries, but your scope is very less.
Very less, my lord, because
Skull fracture was there, leading to clotting of blood, a massive heart attack. The thrombus was there. Then the other aspect, what? There was not even an indication that as if the informant was involved. No indication in the cross-examination. There is no foundation
was
that it is not the accused but the informant.
that condition was never taken in the evidence.
There is no foundation. And the past conduct, yes,
Past
maybe,
conduct,
maybe relevant.
but may be relevant.
And the most important part in his scope to explain in 313, he has not taken up any defense.
Because
He has not even denied. He has admitted all the questions. And sentencing, which you have very fairly pointed out, sentencing, he said, I have told the truth. Please deal with me leniently.
So, my lord, the 313 is very clear, my lord. Supreme Court in 2 of the judgments have found that, my lord, if there is an inculpatory statement, my lord, then, my lord, the court can take into account with the other prosecution evidence laid, my lord, and can convict, my lord.
What is it?
Right. First, 23 2 STR
2023?
2 SCR 119, my lord. Premchand versus State of Maharashtra.
SCR 11,
Premchand versus the
page
state
119.
119, yes, my lord.
Paragraph?
Paragraph 14, my lord, 14, 15, my lord. Internal page 120, my lord.
Yes.
Paragraph 4. A bench of 3 honorable judges of this court in state of UP versus Lakshmi has extensively dealt with the aspect of value or utility of a statement under section 313 CRPC. The object of section 313 CRPC was explained by this court in Sanatan Naskar versus State of Bengal. The rationale behind the requirement to comply with section 313 CRPC was adverted to by this court in Rina Hazarika versus State of Assam. Close on the heels thereof, in Parminder Kaur versus State of Punjab, this court restated the importance of section 313 CRPC upon noticing the views taken in Rina Hazarika and M. Abbas versus State of Kerala. Now, my lord, next page, my lord, para 15. What follows from this authority may briefly be summarized thus. Section 313 CRPC, clause D of subsection 1 is a valuable safeguard in the trial process for the accused to establish his innocence. B. Section 313, which is intended to ensure a direct dialogue between the court and the accused, cast a mandatory duty on the court to question the accused generally on the case for the purpose of enabling him to personally explain any circumstances appearing in the evidence against him. In this case, everything was done, my lord. When questions, the accused may not admit his involvement at all and choose to flatly deny or outrightly repudiate whatever is put to him by the court. D. The accused may even admit or own incriminating circumstances adduced against him to adopt legally recognized defenses. So it was not there, my lord. An accused can make a statement without fear of being cross-examined by the prosecution or the latter having any right to cross-examine him. The explanation that the accused may furnish cannot be considered in isolation, but has to be considered in conjunction with the evidence adduced by the prosecution, and therefore no conviction can be premised solely on the basis of section 313 statement. Statement of the accused in course of examination under section 313, since not on oath, do not constitute evidence under section 3 of the Evidence Act. Yet, now, my lord, this part, the answers given are relevant for finding the truth and examining the veracity of the prosecution case. H. The accused cannot be dissected to only rely. Sorry, my lord, once again I'm reading H. Statements of the accused cannot be dissected to rely only on the inculpatory part and ignore the exculpatory part, and have to be read in the whole, inter alia, to test the authenticity of the exculpatory nature of the admission. If the accused takes a defense and offers any alternative version of event or interpretation, the court has to carefully analyze and consider his statement. Any failure to consider the accused's explanation of incriminating circumstances in a given case may vitiate the trial or endanger the conviction. So, my lord, here in this case, my lord, G says that yet the answer given are relevant and for finding the truth and examining the veracity of the prosecution case. H says that the inculpatory part can be relied by the prosecution. So, my lord, this admission on the part of the accused, my lord, even taken with the prosecution, my lord, in that case, my lord, the conviction was, in my understanding, was correct, my lord, because the past antecedents were also taken care of, my lord. Page 129, my lord. Page 129, para 19, my lord. Now, in this case, my lord, exhibit 96 was the, my lord, the written
Yes.
statement was submitted in the form of 313, my lord, by the accused. So it says that exhibit 96 refers to inculpatory admission as well as seeks to bring out exculpatory circumstances. That statement has to be read in its entirety. The inculpatory admission emerging from this statement against the appellants are his presence at the spot and sustaining of injuries by the victim and the other prosecution witness while the appellant as claimed was attempting to save himself from getting injured. The exculpatory circumstances thought to be established are the appellant's description of the act complained of as involuntary, which was compelled by the inevitable circumstances and not guided by choice, and sustaining of injury by him in the same transaction. Para 20. In view of the inculpatory admission appearing from Exhibit 96, the trial court at the High Court, while concurring the trial court, need not have to labor much to convict the appellant as the person instrumental for the homicidal death of the victim by discussing the evidence laid in course of the trial. So it's very same case here. Since there was an admission, my lord, which is corroborating the prosecution evidence, my lord, the appellant present at the spot of and the victim and the injured witness sustaining injury in the course of struggle could be held to have been established from Exhibit 96. However, not looking into Exhibit 19 with other evidence on record, what the trial court omitted to consider is whether the prosecution was justified in claiming that the offensive act amounted to culpable homicide amounting to murder, or whether the appellant being guilty of the culpable homicide not amounting to murder deserves punishment under Section 304, Part 2.
In that case, 304 exception, 302 exception, 300 exception 4 was taken into consideration and the conviction was altered. Okay. Yes. Yes, madam.
Lordship, almost all the prosecution witnesses found the accused person standing with a weapon of offense in his hand, your Lordship. PW1, who has also seen the accused standing with a stick. Then there is extrajudicial confession method. Then PW2 has also seen the accused standing with a stick, my lord. Even the PW3 also says so, your lordship, standing with a piece of brittle nut tree, my lord. PW4 is the doctor. PW5 has also seen accused Bilal was standing with lathi, my lord. Then PW6 has also said, my lord, accused was standing with a lathi. But here, PW1, PW6, and PW8, lordship, they talk about the conduct of the experts. So all these witnesses have deposed that prosecution have deposed that accused was found standing with a brittle stick with his hand on his hand, your lordship, which is seized by the IO, your lordship. Then, your lordship, PW1 says, my lord, accused was shouting that he killed his mother. That factor may also be taken into consideration, which goes in favor of the prosecution, my lord.
Now you have said extrajudicial confession.
Yes, to PW1, my lord.
One.
Yes. Then the conduct, my lord, accused was shouting that he killed his mother, which has been adduced by PW1, my lord.
Okay.
And regarding conduct, your lordship, may I rely on PW6, my lord?
PW6 also,
PW6, page 20.
also says about conduct.
Yes. Accusers being armed with small lathi fort line from the top, made of brittle nut tree, and accuser shouting, saying that his mother died. That is not, may not be relevant, but this his previous conduct
Your Lordship, accused is a person of very hot, that previous conduct of the accused, and previously he did such type of incident, and as such, out of fear, I did not proceed further and left the place of occurrence. In cross-examination, he also deposed as such, my lord, that it is such type of incident, and as such, out of fear, I did not proceed further. Even your Lordship, PW8 also says so. Lordship may kindly have a look the evidence of PW8. Sixth line. I saw his mother lying dead on the floor of the veranda of the house, and there was a piece of betel nut tree in the hands of the accused, and the accused was shouting towards me.
8 also saw a stick.
Yes, betel nut tree in the hands of the accused, and the accused was shouting towards me not to come near his mother, otherwise he would kill us. I found the accused dragging his mother from the veranda to inside his house. Thereafter, Lordship, about his previous conduct, a few years back, the accused killed one Jamil master of our village. Thereafter, the accused also brutally assaulted his sister-in-law, even inflicted down blow.
Except the official witness.
My lord.
Except the official witness,
My lord.
the doctor and the IO. All the other witnesses have seen the accused with the stick on his hand, in his hand.
My lord.
And while the IO had come, stick was found, but not in his hands. It was lying.
Right.
Because he came at around 3 hours
Oh.
after the incident. And the other official witness is obviously the doctor who would not have said that.
Right.
Yes.
So these are the factors, circumstances which go against the appellant, your lordship, coupled with his admission in 313. And regarding the motive reason, your lordship, answer number 6. Answer to question number 6, lordship, page 28. Page 30. Oh, this is as regards previous.
No, there is a question.
15, huh?
There is a question.
Page 33, I think.
15.
There is a question.
Yes. Lordship, he has admitted it. I have killed my mother as she refused to hand over.
This is question number 15, I think.
Yes. Answer to question number 15. Refused to hand over her BPL card to me. So he has admitted it, Lordship. Although on the basis of preventive statement, even if he admitted or denied it, he may remain silent. The Lordship may not give conviction. But here, these are the circumstances which coupled with the admission in preventive. So Lordship, the prosecution have able to prove the case beyond reasonable doubt that accused is the perpetrator of crime. Even if Lordship assumes that he is not the perpetrator, he did not make any endeavor to take the dead body to the hospital or give any treatment to her, your lordship. He just remained silent. He's just standing beside the dead body, even threatened the other person, my lord, who came, lordship, to see the incident. So these are the factors which circumstances which go against the.
What is the meaning of MI in the doctor's evidence?
Lordship card. My आपका case है.
Massive MI.
In my opinion, the cause of death is due to massive MI.
What is MI?
Myocardial infection.
Infraction.
Commonly known as heart attack. Another.
No, so that it is what we are trying to
Yes.
put the question. The assault was on the head.
Yes.
Assault was on the head, causing fracture.
Right.
But the death was due to MI.
MI.
Is it connected?
Maybe connected
No,
because of the
maybe-
injury.
Maybe will not do. It has to be connected. Maybe will not do.
Lordship, it is connected because of the injury. Lordship, she could not bear it.
No. That is
Because of the
different.
shock, my lord.
No. It is not a result of hemorrhage due to shock. It is a result
Let's
of
see
MI.
the postmortem report.
Yes. Now, postmortem we have just seen.
My lord.
We have just seen. Normally, what is due to shock and hemorrhage due to shock, but that is not what it is. Death due to massive heart attack due to blockage of coronary artery by thrombosis.
My lord.
Cardiogenic shock, cardiorespiratory failure.
My lord.
See, the cause of death is the heart attack
My lord.
because there was a thrombosis.
My lord.
And he has also stated that in the
Presence
Lordship. my
of
lord.
one large clot in the
Yes,
descending
please,
branch
please.
of left coronary artery. Page 17, my lord.
yes.
Last para, my lord.
Hypertrophic of left artery. So this is the reason.
No,
Left
no.
side of
This
heart
is
is still
the,
white.
this is the
There are-
reason is the heart attack.
Yes.
Heart attack.
Injuries on the head.
Head.
And she was previously also
Yes, yes.
suffering from heart problem.
Heart problem. So we are just trying to see there is a mention of thrombosis.
Yes. Oh, it's there. It is there.
Thrombosis
Yes.
is there at more detailed description
Yes.
at page 57.
Yes.
Blockage by artery by thrombosis.
Yes.
What is a thrombosis? Do you know what is a thrombosis?
What?
Thrombosis is the clotting of the
Clotting
blood.
of blood.
When the passage of blood is blocked because of a particular clot.
My lord.
The clot may go from the brain to the heart
Yes.
and it may cause the thrombosis in the heart. So that is why I was trying to understand from page 55 what is the nature of the injuries which was actually caused on the skull.
Right.
Come to page 55. Soft tissue swelling on just left side of frontal bone, collection of 100 ml of blood in extradural space in left frontal region, hairline fracture. Hairline fracture on left frontal bone.
And the clot was found here itself. Only.
No. Cloth was found in the heart.
No,
There is
my lord.
mention.
At page 55, my lord.
Yes. Where is the cloth? There is no cloth.
Yes, my lord.
Where?
My lord, page 55, my lord.
Yes.
First column, scalp,
Yes.
skull and vertebrae.
Yes.
Now, third lord, you will find collection of 100 ml of blood in extra dual
There is no
space
clot.
in left frontal region.
There is no
This
clothing.
was on
There is no clothing. Clothing is only in the heart.
the heart.
But heart is at page 56, my lord.
Yes.
Presence of one large clot
Yes.
in the descending branch of left coronary.
Yes.
Coronary artery, left side of the heart is filled right there. But the 100 ml part is written there itself in my lord, page 55. At the skull part.
That is collection.
Yes, correct.
But heart, there is presence of one large
The
cloth.
clot was there in
Now,
the heart.
we are just trying to understand whether the injury on the head has resulted in
The clot at the
formation of one large clot
clot on the
in the descending process. Because if you come to the ultimate opinion at page 58, in my opinion, the cause of death is due to massive MI. The primary reason is massive MI, along with grievous injury on the head.
Combined. Massive MI.
But my lord, the cardiogenic shock in the Google, my lord, it says that cardiogenic shock can be caused by problems outside the heart, including fluid buildup in the chest, internal bleeding. And like after building up in the chest, comma, internal bleeding or blood loss, comma, or pulmonary embolism, which occurs when a blood clot gets stuck in an artery of the lung.
That is it. So the clothing has to be in the artery of the heart.
Sometimes internal bleeding also
Death
can
is
be.
not because of any stroke.
Yes, my
It
lord.
is death because of the heart attack,
Heart
not
attack.
of the stroke of the brain. The
But here-
thrombosis was in the heart.
Yes, but here, my lord, one part extra says that if there is an internal bleeding in the body, then the clotting can be there in artery part.
The aspect of your lordship,
So read the third opinion regarding more detailed description of injury or disease.
Yes.
This is the
all
last.
the injuries
No,
prescribed.
last one.
It may elicit after attack, there are some spearing on body, including the heart.
It may please see the original record there with you.
Records.
Because the mother was also not very aged. 60 years.
60.
60. It is not a very frail lady being attacked on the head. More detailed.
All the,
The fourth one. It may
it may it is the
the experts in the translation section could not detect, so perhaps it
My lord,
cannot be possible for you.
it's the doctor handwriting.
That's why they have written illegible.
Send it to a pharmacist. He'll be able to read.
Yes, sir.
Doctor's handwriting only a pharmacist can read.
Yes, sir. However illegible they can read.
Okay, doesn't
it
matter.
may form after attack, there are some spearing on body, including the
We are just trying to find a leeway to convert, but it is chances are very less.
lordship, so I'll be relying on one judgment.
Yes, please. Regarding what point?
Regarding the conduct, my lord, 2010 7 SC 75 lordship. Sorry,
2010, 7 SCC,
7 SC 759. Chenda versus State of Chhattisgarh.
CHENNA,
CHENDA. Chenda
Chenda.
versus State of Chhattisgarh. Oh, lordship, I'm sorry. It's 2013 12 SCC 110.
This one 2013.
12 SCC 110. Para 23.
Name is same.
Name is
Chenda.
Chenda versus State of Chhattisgarh.
Para?
Para 23.
On what point?
These are
Previous-
some factors which are required to be taken into consideration before awarding appropriate sentence to the accused. These factors are only illustrative in character and not exhaustive. Each case has to be seen from a spatial perspective. The relevant factors are under motive or previous enmity, whether the incident had taken place on the spur of the moment, the intention, knowledge of the accused while inflicting the blow or injury, whether the death ensures instantaneously or the victim died after several days, the gravity, dimension, and nature of injury, the age and general health condition of the accused, whether the injury was caused without premeditation in a sudden fight, the nature and size of weapon used for inflicting the injury, and the force with which the blow was inflicted, the criminal background and adverse history of the accused, whether the injury inflicted was not sufficient in the ordinary course of nature to cause death, but the death was because of shock, number of other criminal cases pending against the accused, incident occurred within the family members of close relations, the conduct and behavior of the accused after the incident, whether the accused had taken the injured or deceased to the hospital immediately to ensure that that she gets proper medical treatment. These are some of the factors which can be taken into consideration while granting an appropriate sentence rate. Here, para 60 also talks about my conduct. Subpara 16 of para 24. And regarding the admission in 313, 2010, 7 SCC 759.
Oh, this is, oh,
Arnidhar Murder.
Dharanidhar.
Arnidhar versus State of UP. Reported in 2010, 7 SCC 759.
Paragraph?
Para 13.
Okay.
Para 13 may I read it?
Yes.
Still, another aspect of this case is that when the accused were being examined under Section 312 CRPC, they barely denied the incident and stated that there were land disputes. No evidence in their behalf had been adduced by the accused person. Even if this statement is assumed to be correct, now the accused cannot turn their back and deny the existence of dispute between the parties. This should further be one of the links in the chain completing the crime of murder. Besides giving a general denial even to the basic facts, the accused in the last two questions put to them by the court in the statement under Section 312 CRPC stated the Deopal, etc. are from the same family and they have falsely given evidence against them. They also stated that Deopal and the family of the deceased wanted to grab their land and therefore they have falsely implicated them in the present case. It is a settled principle of law that a statement made by the accused under Section 312 CRPC can be used by the court to the extent that it is in line with the case of prosecution. The same cannot be the sole basis for convicting the accused. In the present case, the statement of accused before the court to some extent falls in line with the case of the prosecution, and to that extent, the case of the prosecution can be substantiated and treated as correct by the court. The legislative intent behind this section appears to have twin objects. Firstly, to provide an opportunity to the accused to explain the circumstances appearing against him. Secondly, for the court to have an opportunity to examine the accused and elicit an explanation from him, which may be free from the fear of being trapped for an embarrassing admission or statement. The proper methodology to be adopted by the court while recording the statement of the accused under Section 313 of the CRPC is to invite the attention of the accused to the circumstances and substantial evidence in relation to the offense for which he has been charged and invite the explanation. In other words, it provides an opportunity to an accused to state before the court as to what is the truth and what is his defense. In accordance with law, it was for the accused to avail of the opportunity, and if he fails to do so, then it is for the court to examine the case of prosecution on his evidence with reference to the statement made by the accused under section before the as to what is defense in accordance with law. It is for the accused to avail of the opportunity. If he fails to do so, then it is for the court to examine the case of the prosecution on his evidence with reference to the statement made by the accused under Section 312 CRPC. In Hate Singh Bhagat Singh, the state of Madhya Bharat, AR 1953 SC 468, while dealing with Section 342 of the old CRPC, equivalent to Section 313, the present CRPC observed the answer of the accused given can be used in other inquiries or trials for other offences. In the case of Narayan Singh versus State of Punjab, 1963 3 STR 678, the pre-judgment of this court held as under Section 342 CRPC, criminal procedure by the first subsection, in so far as it is material, the court at any stage of the inquiry or trial after the witnesses for the prosecution have been examined before the accused is called upon for his defense shall put a question to the accused person for the purpose of enabling him to explain any circumstance appearing in the evidence against him. Examining under Section 342 is primarily to be directed to those matters in which evidence has been laid to the prosecution to ascertain from the accused his personal explanation, if any. of the incident which forms the subject matter of the charge and his defense. By subsection 3, the answers given by the accused may be taken into consideration at the inferior trial. The accused person in his examination under 342 confesses to the commission of the offense charged against him. The court may, relying upon that confession, proceed to convict him, but if he does not confess and in explaining the circumstances appearing in the evidence against him, sets up his own version and seeks to explain his conduct, pleading that he has committed the offense, the statement of the accused can only be taken into consideration in its entirety. And Narayan 6 case has also been relied upon. The last, not last line, there's a line minor. It is thus well established in law that admission and confession of accused in the statement under section 312 CRPC recorded in the course of trial can be acted upon by the court, can rely on this confession process to convict. So admission coupled with the prosecution case evidence, my lord. On the basis of that, the lordship may appeal the conviction. And one of the factor, lordship, he killed his own mother. That factor. Yes.
Okay.
Here we 80 amicus, B here, APP. Hearings concluded, judgment is reserved. Second, matter will not have it today. Another hearing is there.
The next matter will have some other date. Please inform Mr. Ahmed.